Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. A subscriber to our YouTube channel sent a great question in. Hey Patrick, can you give us some tips, recommendations, and steps for smooth transition, caregiving responsibilities for our loved one? Number three, you got to make sure, folks, and this should be like part of pre-planning, you got to make sure that your disabled, incapacitated loved one has already in place what I call Big Six disability planning. What is a Big Six disability planning? Durable power of attorney to manage finances, healthcare proxy to manage medical affairs, advanced medical directives, which is a medical checklist. We're going to say HIPAA authorization, Health Insurance Portability Accountability Act, to get access to medical records. Number five, a living will, which is also referred to as a DNR. And then I would recommend what I call a spoon-fed directive, because they spoon-feed folks when they go to facilities like nursing homes and memory care units. You need to have all this in writing prior to your loved one becoming completely incapacitated. And from my experience, folks either don't have them or have some of them, but not all, and they're not updated and not current. So you need to make sure you have current Big Six disability plan. And I'm going to give you number seven. In this situation, if you have a loved one who's completely incapacitated with other folks overseeing their care, you need medical order regarding life-sustaining treatment. Some places call it a POLS, a physician's order regarding life-sustaining treatment, right? Because this is going to say end-of-life wishes. Do not hospitalize. Do not transport, things of that nature. Do not resuscitate. You need to have all this in writing, folks. And from my experience, this needs to be monitored and updated as needed. You need to keep your finger on the pulse of this, because from my experience, we had a case a number of years ago where our client had a MOLS. They filled it out as the healthcare agent for their incapacitated spouse, but several months later, it was medically futile to continue giving medical services to their loved one. The facility that they were transferred to said, hey, in our records, the MOLS says resuscitate. Even though it was medically futile, they had to go by the paperwork they had on record. And the family was frantic because it was beyond what they call the doctrine of futility, where no matter what medical care was given, it wasn't going to help the situation. Strong advice, recommendation, monitor it and keep it updated as your loved one's journey through life. And really important, folks, if you got a plan B, because you're taking care of a loved one at home, you got to have a plan B. Like if things don't work out at home, if there are significant fall risk, you need to have a plan B, other accommodations. Where can they go in a safe manner? Is it a skilled nursing facility? Is it an assisted living facility? Or is it a memory care unit if they had significant cognitive decline like dementia or Alzheimer's? These typically are private pay. This right here, skilled nursing facility, could be private pay or Medicaid. And that's the other piece of this, the cost involved. Skilled nursing facility could be $20,000 per month private pay here in the Commonwealth. Assisted living facility could be half of that. Memory care could be $10,000 or more per month. So you got to figure out the cost. How is the family going to pay for that? Average period of disability could be about 3 years. So you want to crunch the numbers, and you want to work with an experienced elder law attorney who's putting a plan in place and maybe even assisting the family with Medicaid crisis planning, with things like single premium immediate annuities or Medicaid compliant annuities, and also what we call a 1396, a D4C trust, which is also called a community pooled trust. Folks, one other caution here, another important tip that's often overlooked. Say you have Bill and Mary, and say Bill is the one who's very incapacitated. All focus is on Bill. But Mary's been the caregiver for Bill for several years, and that's a very stressful job that can be very detrimental to their health. It's not uncommon if something happens to Mary in the community first, if she goes first, right, and they have assets, and you don't have the proper estate plan in place, all those assets are going to go over here to Bill. What's that going to do? It's going to put him over asset, and he can lose or jeopardize his Medicaid benefits. So stopgap measure could be a Medicaid will with a testamentary trust. Again, this is not do-it-yourself projects. These are very strategic, fairly complex legal strategies that you need to work with an experienced elder law attorney to cross the T's and dot the I's to get this right, folks. Hopefully you found this video helpful. Post a comment or question. Please share the video with others that you think could benefit from this. Be sure to click the subscribe button and click that notification bell, because we'll keep you updated on new video releases. Thanks for joining us.